Your Honor, may it please the court. My name is Pradeep Subedi, student ID KAC 3097. I would like to introduce my colleague.
My name is Usman Hamid Malik and the student ID is VSS 31383.
My name is Zaza Ashraf and the student ID is VSS 8020.
My name is Neeraj Kumar and my student ID is ABNN 3135.
Your Honor, may it please the court. I counsel for Mr. Shaddock and we represent as a plaintiff against the case between Mr. Shaddock and Parramatta City Council. The issue before the court today is whether my client is liable for the compensation against the act carried by Parramatta City Council. So what happened was on 21st of May 1973, the appellant entered into a property. The appellant, as in Mr. Shaddock, he entered into a property in the council of Parramatta to buy a house on the corner of Maker and O'Connell Street, Parramatta. Settlement under the contract took place on 1973. The property was bought for the purpose of redevelopment. The appellant would not have bought the property if they had known that the land would be substantially affected by the road widening proposal. On 10th of May 1973, me as being a solicitor, I called to the Parramatta City Council and asked if there is any kind of road widening proposal on coming days or not. And I was being told there was not. So on the following day, we lost the council a document in the form prepared by the laws sessioners and commonly used, by which we made an application for certificates under Section 160 of the Local Government Act 1990 as amended, and for other information indicated where under remarks. Under that heading, we asked the question: is the property affected or proposed to be affected by any of the following? Proposal, as in like land or road widening program. The form showed that as a purchaser of one of the appellant companies, and instead that purpose for which information was required was comprehensive. In response to this application, we received a certificate stating that there wasn't any kind of such proposal. So, as a matter of fact, prescribed by clause 9 of Ordinance 107, as matters with respect to the council is authorized to issue certificates under the section 342. However, in the consequences, the appellant company believed that the absence of any notation as a local road widening proposal on the certificate indicated that there was no such proposal, which was quite surprising. During the period from 1970 to May 1973, which was quite surprising that we had received about 8 such certificates. And evidence given by the town clerk of the council showed that it was a practice of the council to give the information to each and everybody other than which the council was authorized, including information as to road widening program, both orally by the telephone and by the endorsement on certificates issued under the section 342. In the light of practice was led and believed by the absence of such notation on the certificate, which we received that there was no relevant wide proposal program. Although the relevant proposal were not formally adopted until February 1974, there was little doubt in May 1973 that they would be implemented and would seriously be affecting subjected land.
Your Honor, there is no doubt that the officer of the council was answered the telephone was careless in stating that there were no such road widening proposals affecting the land. It is, however, a critical question the council in issuing a certificate, which was silent to the road widening proposal, thereby informed me that there were no such proposal. The question is not free of difficulty. The law of evidence provides an analogy in this case. The question in this present case, having regard to the practice of the council to endorse such information as to the road widening proposals at the foot of the certificate, its failure to do so when it had been asked, by the use of form commonly implied. to supply the information for convincing progress could reasonably have been understood by the recipient of the certificate as the information that no proposal existed. The council ought to have known information that no proposal existed, and the council ought to have known, although me had not expressly informed it is of my awareness as a practice, that it would probably be so understood. The return of the certificate unendorsed was therefore tantamount to the giving information that there were no such proposals. Clearly, it was careless to give such certificate. It is believed whenever a person gives information or advice to another upon a serious matter in circumstances where the speaker, here in this case the speaker means the council, realizes ought to have realized that he is being trusted to give his best of his information or advice as a basis for action on the part of to the other party, and it is reasonable in the circumstances for other party to act on the information or advice, that the speaker comes under a duty to exercise reasonable care in the provision of the information, or he chooses to give it seems very original in this case.
Your Honor, there were two main principles. Number one, whether the circumstances in which the requests were made, such as to raise a duty of care, and if so, number two, whether there was a breach of the duty. The inquiry was oral and informal. I did not identify the officer whom I spoke to, nor I did follow up his oral request by confirming the conversation in writing. There is some room for doubt whether the offer realized or ought to have realized that me and my clients were relying on the information supplied, or that they were intending to act upon it. The second request, the written application for certificate, stands in a different position. It was formal request made by me. The respondent dealt with it in the same fashion as it dealt with other requests at that time. It treated it as a request for information additional to the matters, notwithstanding that a duplicate form did not accompany the request.
Your Honor, so the point made by the counsel was rejected that no duty of care arose because I did not bring home it to the purpose to which the information would be put. True is that I did not state why the information was wanted or what action my client proposed to take on the strength of it. But the existing of a duty of care does not depend upon a knowledge on the part of a speaker, which is a counsel here in the case, of the precise use to which the information will be put. It is enough if I know or ought to know that the inquiry is requesting it for a serious buyer, that I purpose to act it upon my clients and may suffer loss if it proves to be inaccurate. These requirements were satisfied in the present case that the fact that the request was made in association with an application for a certificate by me would cause any reasonable man to conclude the request was made for a serious purpose on the behalf of an owner, intending purchaser or lender who intended to be act upon the information provided and would in all probability suffer loss if the information were inaccurate.
Your Honor, lastly, concluding the fact that it can be clearly seen, my client was noted with a negligible misstatement, which comes from the fact that the counsel was unable to maintain a proper duty of care. So it can be foreseen or reasonable actions should be carried out compensating my client as Shaddock. That's all, Your Honor.